Shvidler against Secretary of State for Foreign, Commonwealth and Development Affairs, and Dalston Projects and others against Secretary of State for Transport.
Lady Rose will explain the court's judgment.
These two appeals concern important questions about the operation of the sanctions regime put in place by the United Kingdom government to put pressure on the Russian Federation to end its aggressive war against Ukraine. The judgment also addresses important questions regarding the proportionality of any interference with a sanctioned person's rights under the Human Rights Convention. The two appellants have been made subject to sanctions imposed on them under powers conferred on ministers by the Russia Sanctions EU Exit Regulations 2019 as amended in 2022. There are other sets of sanctions regulations, all made under powers in the Sanctions and Money Laundering Act 2018, targeting various different countries. Mr Shvidler was designated by the Foreign Secretary on 24th of March 2022, a month after Russia invaded Ukraine. The effect of being designated is that all his assets worldwide are frozen, and it is a criminal offence for anyone to deal with him in either a private or commercial capacity, subject to a few exceptions. The other appellant, Dalston Projects Limited, owns a luxury yacht called the Phi. The Secretary of State for Transport took a decision on 28 March 2022 to detain the yacht and prevent it from being moved. The effect of this is that the Phi has been moored in London since then. Mr Nomenko is the ultimate owner of the yacht. He complains that he has been prevented from earning substantial income from chartering the yacht out during the spring and summer Mediterranean sailing seasons. Mr Shvidler and Dalston Projects both challenge the ministerial decisions imposing sanctions on them. They claim that the sanctions disproportionately interfere with their private life, contrary to Article 8 of the Human Rights Convention, and disproportionately affect their rights to their property, contrary to Article 1 of the First Protocol to the Convention. It is accepted by the government that there has been an interference with Mr Shvidler's and Dalston Project's rights, and that needs to be justified. The issue between the parties is whether that interference is justified in light of the aims pursued by the sanctions, or whether the sanctions are disproportionate and therefore unlawful. The appellant's challenges in these proceedings were dismissed at first instance in two judgments in the High Court. Their appeals, heard together by the Court of Appeal, were both dismissed. The appellants appealed to the Supreme Court. The Supreme Court, by a majority, dismisses the appeal of Mr Shvidler and unanimously dismisses the appeal of Dalston Projects. Lord Sales and I give the leading judgment, with Lord Reid and Lord Richards agreeing. Lord Leggett gives a judgment dissenting in relation to Mr Shvidler's appeal. A large part of the judgment discusses how courts at different levels should carry out the task of reviewing a decision taken by a minister or by some other branch of the executive when that decision is challenged on grounds that it is disproportionate. The principles set out in the judgment are as follows. When a first instance court, such as the High Court of England and Wales, is deciding a challenge like this, the court's function is not merely a secondary reviewing function to decide whether the primary decision maker, such as a minister or an official in a government department, misdirected himself or herself, or acted irrationally, or made some mistake in the procedure they followed. Instead, the first instance court must decide for itself whether there has actually been a violation of Human Rights Convention. However, when a court is taking its own decision on proportionality, it will often be appropriate to accord some respect to the views of the government. How much respect will depend on the importance of the right involved, the degree to which the right is interfered with by the measure being challenged, and the extent to which the courts are well placed to adjudicate the balance of various rights and interests engaged. On the facts of these cases, the relevant ministers, that is, the Foreign Secretary and the Transport Secretary, have superior institutional competence as compared to the court when it comes to assessing matters of national security and the conduct of the UK's international relations. So when the court is deciding whether a measure is proportionate in this field, the views of the Foreign Secretary and the Transport Secretary should be accorded a large measure of respect as to how best to respond to Russia's actions in Ukraine. So when a first instance court has taken its own decision on proportionality and a party appeals that decision, what should be the approach of the appeal court? There are two possible approaches. In some cases, the appellate court defers to the first instance judge and will only intervene where that judge has made a significant error. This is likely to be the more appropriate approach where the case does not raise any significant issue of principle, or is not a case where the appellate court is effectively giving guidance likely to be relied on by lower courts in cases in the future. But in other cases, the appellate court should not treat its role as so limited, but instead should again make its own fresh assessment of the proportionality of the measure in question. This approach is likely to be appropriate where the appeal court's decision is one which will provide guidance for other later cases because there is a general principle arising, or where the subject matter has major social or political significance. In that kind of case, the public will rightly expect the more senior judges in the appellate court to exercise their own judgment as to whether the measure in question is proportionate and lawful. The court considers that Mr Shvidler and Dalston projects cases are ones where the Supreme Court should consider afresh whether the sanctions imposed on Mr Shvidler and on Mr Nomenko's yacht are proportionate. Each of these cases is essentially a test case regarding the proportionality of sanctions in respect of Russia as a result of the invasion of Ukraine. So this court must assess for itself the evidence regarding the impact of the measures on Mr Shvidler and his family and on Dalston yachts and Mr Nomenko, and the proportionality of the sanctions imposed upon them. So applying the proportionality assessment afresh, the judgment goes through the different stages of a test that has been set out in many earlier cases as to whether a measure which interferes with someone's rights is proportionate or not. The first stage of that test is whether the measures have a legitimate aim. There can be no doubt that the 2019 sanctions regulations do pursue a legitimate aim in attempting to limit and deter Russian aggression in Ukraine. The invasion represents an egregious violation of international law and the UN Charter, constituting one of the most serious threats to European security and the international order since the end of the Second World War. Moving to the second stage, the measures against Mr Shvidler and for the detention of the FI, the yacht, are rationally connected to this aim. There is a difficulty here because it's very hard for the government and for the court to understand fully what factors do or do not influence President Putin and his government in the prosecution of the war. It's also difficult to assess whether any particular sanctions measure, or indeed any of the measures put in place by the UK and its international partners, are working in the sense that they are constraining Russia's conduct of the war. There is, however, no need to show that particular sanctions imposed on these two individual people would by themselves achieve the legitimate aim. It is important to have regard to the cumulative effect of all the measures taken. All that is needed is for the Secretary of State to show some plausible contribution made to that effect by the measure in question. The rational connection in relation to the detention of the yacht is clear. Mr Nomenko claims he could earn very considerable income by chartering out the FI to other wealthy individuals, and it's likely that that income would make its way to him to be spent by him in Russia, where he lives. The economic impact on him is also likely to have political ramifications, given that the deprivation of a prestige asset by reason of Russia's invasion of Ukraine is likely to, or may at least dispose Mr Nomenko to be discontented with the Russian regime. There is therefore clearly a rational connection between the detention of the FI and the aims of the 2019 regulations. In relation to Mr Shvidler, the court accepts the government's evidence that the sanctions imposed on him will send a signal both to him and to others associated with persons involved in the Russian elite that there are negative consequences to having implicitly legitimized the Russian government's actions. The hope is that this will disincentivize others from associating with the government or encourage them even actually to oppose it in the future, although the court recognizes that Mr Shvidler cannot be expected to place himself and his family in physical danger. The final stage in this case is to consider whether a fair balance has been struck between the rights of these individuals and the interests of the wider community. Whilst Mr Numenko is impeded in the use of a luxury asset, it's not suggested that this would have any significant effect on how he lives, nor that he cannot absorb the costs involved in maintaining the vessel here. The designation of Mr Shvidler also strikes a fair balance, taking account of the importance of the public policy aim. There is no doubt that the measures have had a severe, open-ended and drastic effect on Mr Shvidler and his family. Nevertheless, their core needs can be met through a licensing system which the government has set up and to which they can apply to be allowed to use their money for certain purposes. So they can have enough money released to them to enable them to live modestly, even if their luxury lifestyle and private school education may have been disrupted. Furthermore, the main point is that sanctions often have to be severe and open-ended if they are to be effective. The Supreme Court, therefore, dismisses the appeals.